Pascal. You are now rocking with that dude Pascal. We be going wild, Haitian in the building, so original. Got the haters catching feelings. Get your hands up to the ceiling and keep them held high. Cause St. Louis isn't ready. Forget about it, goodbye. Hold on, we just saying hi. Five somebody rise up weekdays. Catch us live. Somebody, let's go.
Good evening, everybody. Yes, it's real. It's actually happening now. Welcome to the Pascal Show. Hope you guys are all doing well out there. Hope this show finds you in great spirits, as it should. Okay, because it's the freaking weekend now, y'all. It's finally here. Oh, it's the weekend. So you guys should be very happy. I don't know about you guys, but I am definitely happy about it. Okay, maybe I'll get some sleep this weekend. Probably not, but wishful thinking, right? Anyway, guys, we are here because a hearing just ended just about 25 minutes ago, okay, for the Bryan Kohberger trial, for the Bryan Kohberger Idaho 4 case. And a lot of us have been wondering what's been going on, what happened. There were a lot of motions that they had to go through today. There was a lot to go through in this hearing. And there was a lot of arguments, especially on one main one. That one was thicker than a snicker, everybody. Thicker than a snicker. And we're going to be getting down to the nitty gritty on this for real. So please, before we get into it, and let's not forget, we got our good friend, okay, superwoman herself, Andrea Burkhart, in the house. She's going to give us everything. She was boots on the ground. She was a fly on the, she's not a fly, but you see what I'm saying. She was like that, a fly on the wall. And she has a lot of information for us. And I'm very excited to hear what she has to say because she was right in that room, y'all, and heard everything. She got notes, guys. She got a Moby Dick thick legal pad filled with notes. So get ready. We got a lot of stuff to go through today or tonight. Okay, so do me a favor because it really would mean a lot. Some housekeeping really quick. Hit that like button down below if you're watching on YouTube. If you're watching on Facebook, make sure you hit that reaction button as well. That would really mean a lot. For those y'all on YouTube, I don't know what to tell you. If this is your first time checking out this show, make sure you hit that subscribe button. And also, y'all over in Facebook, hit that follow button as well. It'd be great to have you a part of the Pascal Show family, okay? And of course, if you want to support the channel and you're over on the YouTube channel, hit that join button down below. Consider becoming a family member. That would really help the show, help this channel, because these purple lights don't pay themselves, okay? And those little strips, they be expensive. No, they're not, but you know what I'm saying, okay? I got mouths to feed. Whatever. Anyway, guys, we got things to get into. We got a conversation we got to have. There's a lot to go through, so get ready, get some coffee. Well, not coffee, but get something to drink as long as you're not operating heavy machinery, okay? And let's get comfortable and let's have this conversation. It's Friday, guys, and it was one hell of a hearing today. Bryan Kohberger was inside, and his team was fighting for everything today, especially one in particular, the DNA, the genealogy, the genetic genealogy, results that came out, the DNA, how they received it, so on and so forth, how they got to Bryan Kohberger in Pennsylvania when he was arrested and all that stuff. There is so much to talk about with this. And of course, we got many other motions as well, which we will be talking about briefly, but there are two main ones, which is one, of course, the IgG or the DNA argument. And of course, let's not forget the motion to stay, which we will be talking about here very, very shortly. So please welcome, without further ado, we got to get straight into this. Please welcome a good friend of the show. All right. I called her superwoman. I'm going to say it again. Please welcome Andrea Burkhart back to the show. How you doing, Andrea?
I'm doing great. I'm right here outside of the Latah County Courthouse, as you can see. It's right at the end of the day here, but this was a nice little bit of shade to sit and do our recap.
Yes, man. First off, I want to say thank you so much for hopping on and being a part of the conversation on the show. I know you could be doing so many different other things like living your life.
A long way back through a lot of very brown harvested fields right now.
Yes. I don't know. Do you have like some weird I don't know, a craving for potatoes right now? No? Okay.
Who does? Oh, always.
I'm working on my dad jokes right now, okay, guys? But we got to get into some things, okay? Obviously, there was a big, huge court hearing that happened today with Bryan Kohberger. There were many, many motions. The protective order, reconsider order, staying time for a speedy trial, a scheduling order, okay, which is like deadlines for everything that for the defense and the prosecution to bring in the paperwork, bring in the things that they need to have. But then that's only just on the prosecution side. On the defense, there was their third motion to compel, their motion to stay proceedings, a motion to dismiss indictment on grounds of error in grand jury, which we will be diving into that a little bit here as well, and and a motion to alternative remand for preliminary hearing. So we got a few things we got to get into, and I understand you just got out, like I just said, 25 minutes ago. Did they get through everything today? Because it seems like there was so much going on, especially with the DNA conversation. I felt like they weren't going to be able to get through everything in a timely fashion. Did they get through everything?
Yeah, so they did not. They basically deferred the motion to dismiss the grand jury indictment. Those arguments are being held over for I believe they said September the 1st. I'll verify that when we get to the scheduling order, because a lot of deadlines set today. But yes, the bulk of the day got taken up by the arguments relating to the investigative genetic genealogy. Started at 10:30, and they wrapped that up finally about 3 o'clock. So that was by far the bulk of what we were doing.
So mainly it was the conversation about the DNA, the argument about the DNA. So then let's get into that, because I mean, obviously that's the thick piece that took basically all day, or majority of the day. Everything else was pretty quick to get through, which we will talk about the other a few of the other ones as well, especially like the scheduling order, especially the scheduling order as well. But let's talk about this, the DNA, because what we're seeing online, like, from of course they've put out some of the footage of the actual hearing with the DNA, covering the DNA. Now, from what I understand, there were 4 different people that came on behalf of the defense to talk about whether or not this DNA should be used. Now, I'm hearing through the grapevine, of course, that some were just lawyers talking on behalf of the DNA, and not every single one was actually a DNA or genealogy expert. Is that true? And can you clarify that for us a little bit?
Yeah, that's correct. So 2 of the witnesses who testified. Am I gone?
No, you're here.
Okay, sorry, my phone is being weird. One of the
No
witnesses
worries.
who testified are attorneys who specialize in DNA litigation. And so the first guy who testified, Stephen Mercer, is an attorney from the East Coast, and specifically, it is basically kind of on the cutting edge of litigating these issues, because it's a novel technology. It implicates a lot of issues, legally speaking. So he was there to talk about that. There was a second attorney also who has more of a background in genetics, and so her practice is more in consulting. She is working with the defense to help them review the discovery, understand what it is that they have, understand what happened, understand what should be there, what's missing, why it might be missing, and all of those types of things. Then there were 2 other experts that testified, who are genetic genealogists. One of them is a PhD in botany, I believe. The other has no scientific background at all, but she had a degree in criminal justice, I believe. But because this is basically such a cutting edge technology, there isn't really any standardized system or certification or anything like that. It's just something people have learned to do through experience. So this final witness, even though he doesn't sound very experienced, she does this work for a third-party company who does it law enforcement. So she does the type of investigation that we're dealing with in this case, and that's why she was called.
Interesting, because I keep wondering, when it comes to the people that they brought on as DNA experts, would you consider them really DNA experts in the first place? It seems a bit odd that they would just bring in these people in. None of them are really genealogists. You got a botanist that dabbles in genealogy as like, it almost seems like a side hobby. You have, as you said, like Dr. Vargas, who is a state genealogist. So you still have somebody in there, but the other three that were brought in, why bring in two lawyers to talk about this when they're not even experts in that field?
Well, so they are experts in the intersection of law and genetic issues, basically. And so that's why they were brought in. They're not trained geneticists or anything like that, but they've been dealing with these issues for decades. One of the attorneys actually is probably the most qualified scientist of everybody who testified today. She had a bachelor's and I think a master's in genetics, but she has used that in a legal career rather than some kind of hard science career. The other gentleman, expert, the reason why he testified is because he's been involved in some of the early and high-profile litigation on this case. Not on this case, but I mean on this issue. So he's very familiar with how privacy interests are implicated, what types of arguments might be raised, and that type of thing. So that was really his role to kind of alert the court to why, from a legal standpoint, these issues matter.
Interesting. So, okay. So then as far as their argument, as far as the defense argument over the DNA stuff, what did you see in the court? Did you see them have a strong argument, or is this just for the birds?
No, actually, I thought it was quite a strong argument. In fact, I went into the hearing not that impressed with their argument, just based on their written briefing. I thought the state was potentially going to win it on the state's argument that, look, if they're not presenting it at trial and it's not really relevant to what they are going to have to say, then I mean there's maybe some pieces of it that you can see being discoverable, but things like details of the family trees and stuff like that, why would it matter? The defense did an excellent job today of spelling out why that would matter, the types of effects that it has in the analysis, the way that the handling of the sample is implicated because of the two separate profiles, the way that the understanding the relations between the suspect profile and the other potential matches. That's a different sort of statistical setting than they use for the STR profile, which is what the state intends to use at trial. The STR profile is statistically compared to non-related individuals. And so it only kind of means something in a world where you're the only person in your family, and nobody's the only person in their family, right? We all have relatives. So right. The more potentially related people you have, the more it can skew that statistical measure. So that was something that really had not been fleshed out in the briefing at all. And I thought that was quite a strong and important point. The other thing that you get, of course, just from being in the court is a little bit of the gut check impression, from the judge, and judge does us the favor of being a pretty direct kind of guy. He doesn't really hide what he that much, and so he says straight out, this is a death penalty case. We're all concerned about what happens down the road, if there's an appeal, if there's post-conviction relief and stuff like that. And so it just seems to kind of make the most sense to err on the side of caution with this kind of thing. So perhaps maybe tipping his hand a little bit there about the direction that he's likely to go.
I see. And that's the thing too, because I've also noticed that, so for my understanding, they haven't made a decision on this particular piece yet, right?
Yeah, that's
They
correct. And so the state had actually objected to the witnesses testifying because they argued they had late notice of what they were going to be saying.
Mhm.
And so they had reserved the right to call those witnesses back for more cross-examination and to potentially call their own witnesses to rebut that. So that clearly was not going to happen today. But after the conclusion of the hearing, it's not clear that they're going to do that at all. Judge did not rule on it. He's taken it under advisement. So my suspicion is what's going to happen is that the state will contact the court, the parties, let them know, hey, either we need to bring this back to make this record, or we're fine to go ahead and submit with what the court's already heard. And then after that, the judge will likely issue a written decision.
Gotcha. So he hasn't made a decision obviously yet, but he will do like what he has done in the past with the bigger arguments. He'll issue a written statement with the decision in that, correct?
Yeah, I expect a written decision in this one. It is enough of a likely appeal issue just because it is so cutting edge that it's likely he's going to want to have that pretty well documented what his reasoning was.
Yeah. So as far as the prosecution, on the side of the prosecution when it comes to the DNA, what was their, how did they cross? How did they, what was their response to this whole
the state didn't cross
the defense?
The state did not cross any of the witnesses. The state's position was basically that the witnesses weren't necessary, that the lawyer witnesses were just offering, arguments that the attorneys, who represent the parties could present. And they had submitted, they basically just relied on their own declarations from their own expert that they submitted with their briefing. So they didn't present any additional testimony themselves. And so, yeah, their argument is basically just that it's really not relevant because they don't plan to use it. They argued that the defense hadn't really shown a good reason of why it would matter. They argued that they have, their main concern is the privacy interests of the people who would potentially be disclosed, if these family trees are handed over to the defense. And so the defense's suggestion is, well, you can just, put a protective order on that and then the parties can't disclose it. It will remain private and that takes care of that concern. It was sort of rich getting that suggestion from the state that, that they're concerned about the privacy of these folks, right on the heels of getting some of the most detailed testimony I have ever expected to hear from a witness telling us how law enforcement will backdoor some of the limitations in these private DNA databases in order to get access to profiles that have opted out, that did not want to be part of that law enforcement search process. So that was a little bit of a, doesn't quite add up with those two, but be that as it may, there's, of course, no evidence that the state has, in fact, done anything wrong in this case, but just evidence that these techniques are pretty widespread and understood and well known in this community.
So then let's talk about that really quick, because obviously the whole argument is the DNA. The conversation is the DNA with everything. I mean, with all of this. And of course, this makes or break. Guys, this makes or breaks the situation with this trial. I mean, when they continue to press forward, if the DNA is a card that is played or not played, it is a very, very big deal. It can bring in more reasonable doubt into either side's argument. It is very, very big. Okay. And because if you don't have the DNA, if you can't play that DNA card, then it's going to be very tough for the jury to believe that he was even in the room or even in the place in the first place, right? So when it comes to this DNA, I mean, they were able to retrieve this DNA and through this database, through the genetic genealogy websites and whatnot, they were able to connect this DNA to a family member. And that brought the cops to the front door of Bryan Kohberger's parents' home where he was arrested. Now, obviously, there was all these other things playing in part with the car and all these other things. But how, I guess, and I know we've talked about this before, so I'm sorry if I sound like a broken record. But how can they not have this card played in trial? Why are they arguing so hard on this piece right now?
Well, there's a couple reasons. First, we got a lot of emphasis again today on the fact that this is trace DNA. This is, not a like direct blood sample or semen sample or something like that. This is this is trace DNA. This is the kind of thing that's easily transferred and that type of thing. And so some of the limitations with that are what the state is, or what the defense is interested in exploring. For example, they suggested that one of the reasons they need the SMP profile, the SNP profile, they call it, is because, well, first off, they don't even know exactly how this DNA was handled. And so depending on how it was handled for the genetic genealogy, there's different types of information that may potentially be available to the defense. Things that would indicate, for example, that there was contamination, things that might indicate that there was mishandling, that this was a mixture of DNA, all types of different things like that you wouldn't get from the direct STR profile. Also, the ability to potentially evaluate the STR profile itself by comparing it to sort of neighboring locations on the SNP profile. So like all of these things that are technical reasons why the defense wants to be able to access this evidence so that they can explore whether those things are viable or not. But at the end of the day, with the privacy stuff, they're really looking at the potential to move to suppress it. The argument being if police, violated the law or violated people's privacy in order to make these links, that's something that people should be concerned about. One thing that came up in the hearing today from Mr. Mercer, the first witness, which is something that I've looked into myself recently as well, is the fact that when DNA evidence was first developed and coming before the courts in like the early 2000s, the main reason why the court was basically willing to say, we don't think you have an expectation of privacy in your discarded DNA and the profile that police are able to obtain from that, is because the profile that police obtain for identification is extremely limited. It doesn't provide a whole lot of personal information. If you guys can hear that, I've just got to show you if you can see this truck over here. You can't see it, sorry. Anyway.
No. But what about what's going on with that truck?
Oh, there's just a wild truck going by. We've seen it before. It's got a bunch of flags hanging off of it and stuff. Anyway, it's fun. It's a little piece of Idaho.
Wait. No. But what kind of truck is it? You said something about what? A taco truck? What is it?
No, it's just like a little Jeep Wrangler or something like that. But it's got all these flags on it and like blowing off of it, hung on, and it blares this death metal. It's very Idaho. So I wanted to share that, but I'm sorry I missed it.
It's okay. It's okay. If it's a truck shaped like a potato, let me know.
The point that I was making was that the Supreme Court originally said DNA sampling like this, testing like this is fine because the information that police get is very limited. And that's no longer the case with these new techniques with the full genomic profiling and the SNP profiling and stuff like that. They get an enormous amount of information that includes extremely personal stuff like health information, racial background, potentially even things like personality characteristics and stuff like that. So it's a lot more than the court was dealing with when it was first struggling with these questions of the admissibility of DNA and the implications for the Fourth Amendment. So that's why this is such a cutting edge issue, because this technology has not made it before the court, and it really undercuts some of that original reasoning for allowing it in the first place.
Right. And that's the thing, because I know this is still brand new in a way. A lot of people are getting caught. A lot of bad guys are getting caught through this genealogy stuff. So, of course, being able to have some idea of what can be used, what can't be used in the court of law, as far as catching somebody, I get that piece. But when you say that, and I understand the touch DNA and all that stuff too, but when you get all that, you scrub things down, you find this DNA, and they don't use that, or they're arguing not to use it, yet that could be the only person that is connected to the scene. I feel like they need to get some things figured out, but that's just a matter of opinion. Because I also understand that the defense is trying to say that there were other samples of DNA in the room. Can you expand on that a little bit too?
Yeah, the defense did repeat that again today, that there are 3 unidentified male DNA samples associated with the case, 2 that were found inside the home, 1 was found on the glove outside the home. They did not get any more specific than that. Both the defense and the state kind of repeatedly today were intentionally vague. And so this is one of those issues where I think you can see that they're being intentionally vague. Don't know where it was found, don't know if it was in a victim room, don't know if it was in the kitchen, no idea. But nevertheless, they were there. They were there, unidentified males, DNA samples. So that could have some connection. It could be unrelated. We don't know, but it does indicate, obviously other people present in the house, at least with the same strength of connection as Bryan Kohberger.
Gotcha. And of course, I mean, they brought this up. The defense did bring this up in their arguments today in the courtroom. I mean, was that viable? Was that a viable play? Or, did they put some attention to that conversation, or was this just kind of mentioned and then just kind of brushed off?
Well, so the reason why that came up is because it relates to one of these other kind of outstanding discovery disputes where they have been requesting a lot of reports and things like that from the lab, from the FBI. And so there was additional like data and analysis and stuff relating to those unidentified profiles that they had not received. So that it just basically came up in passing because it was one of the other things that's in the motion to compel. They're asking the judge to order the state to turn over.
Gotcha. Okay. Well, I mean, obviously I feel like when it comes to the DNA, but it took all day.
It took all day. Took all day. 4 witnesses takes a lot of time. Even when they don't have a lot to say, it takes a lot of time. I mean, and the state's got to object to all of them. You got to get all that on the record. So.
True. It just blows my mind that a conversation that we just had took about 27 minutes. And it took them 7 hours to get through this.
Well, they
whole
went
thing.
into a lot more detail. In fact, I actually really enjoyed it in court today. It was very educational. They taught us a lot about genetic genealogy and how it works. I mean, I learned a ton about the process. I wasn't really familiar with, exactly step by step, what do you do? And so we got walked through that. One of the witnesses had a PowerPoint to kind of help walk you along that process, see what the work product is. That was one of the issues for the motion to compel as well, because the state had indicated that like there were no notes, no work product, nothing like that. They just kind of did stuff on the computer and didn't record it. And so this witness was basically there to kind of try to call, BS on that and point out the types of things that would ordinarily be produced in this type of investigation. And so, the implication being that probably somebody did it on the state side and it's either there and hasn't been produced, or they, didn't keep it and need to explain why.
Yeah. It's interesting because someone on YouTube just said this. Kathy, I think it's Kathy. Kathleen. Sorry if I'm saying your name wrong. I apologize. But they have a good point here, because 3 unidentified male DNA samples found in the crime scene is very big deals. Okay. It's a very big deal. So why didn't anybody? Okay. I know that they brought it up. The defense brought it up, but why aren't they putting more focus on that more? Maybe diving into it, throwing that into the genealogy database and coming up with the names of their relatives or something like that. You see what I'm saying? Why is it not being something that is being thrown out right now so we can nip that in the bud, whether or not those people are connected to this heinous crime or not?
It sounds like that's exactly what the defense is wanting to do. That's why they are making this request for additional discovery, so that they can do that type of investigation. From the state standpoint, when the state identifies their target, their suspect, they stop looking elsewhere. So they're not, going to continue down these roads because from the state's perspective, these are no longer suspects. Bryan Kohberger is the suspect. So the state doesn't have any interest in kind of undercutting its own theory. That's just part of the adversarial process. You might think, oh, you'd want to turn over every stone to be sure, but that's just realistically not how the process works. So it does look like the defense wants to be able to do that type of investigation themselves, and that's why they're trying to compel more information about it.
So is there going to be an answer, okay, from the judge, from Judge? Weird last name, but Judge, is he going to be able to say, yes, let's play this card, but we do need the other DNA? Or actually, does that throw out the whole case if he says, wait a second, we should get that DNA, those other DNA samples? If there are 3 unidentified male DNA samples that were in the crime scene, we need to do our due diligence and dive into that. I mean, is it possible that he would sit there and go, yeah, we need to postpone this for a little while until we get that fully vetted? What are your thoughts on that?
There is zero chance he would do that unless the parties specifically ask him to do that. And so nothing like that is pending. And in fact, as we'll go when we get into the scheduling order stuff, it really looks like they are getting ready to go on October the 2nd. Everything is, yes. Oh, yes. Everything is geared towards that.
Okay.
So.
No, the reason why I'm shocked is because the scheduling order, the deadlines for all this paperwork, everything that they have, I mean, it's a quick turnaround that they're asking for. Of course, I'm getting ahead of ourselves, and we are going to be talking about that. That was one of the main questions I was going to ask you is, are they going to be seeing trial in October? Are we going to be seeing this in October? But hold on to that for just a second, okay? Because we ain't done yet, obviously. Now, I know that when it comes to the DNA, that's a huge conversation, a huge argument. It's going back and forth like a game of tennis or a match of tennis, and I get that. And we will find out more information in his written decision, hopefully within maybe next week. I mean, he's got to turn this thing around fast, right?
Yeah.
So with that, we'll see what happens here. But there was the motion to stay. Now, can you, for us laymen's out here, explain to us what motion to stay is pertaining to this particular case?
Yeah, so the motion to stay is basically pump the brakes, put a pause on everything. So the speedy trial deadline stops, it pauses, right? The clock stops, and we don't restart it until after the basis for the stay is resolved. And so in this particular case, Idaho has a statute that allows them to ask for a stay if they're going to challenge the grand jury proceedings for irregularity. And so that was the basis for the motion. They argued that there were problems with some of the questionnaires, problems with potentially some of the qualifications based on how those questions were answered, problems with how the jurors were summoned in, that type of thing. Judge denied that motion. He basically said that to the extent there were some irregularities, they're pretty normal. Like they're just the type of thing that you always run into when you have juries. Like people forget to check a box on the questionnaire. It's not like really indicative of anything except that people make mistakes. So it was normal. It was like normal non-compliance, not substantial non-compliance. So he did deny that motion. And then interestingly, he also did effectively grant the state's motion for reconsideration of the earlier stay. That had been an issue because it had basically resulted in extending the speedy trial deadline for 37 days. The state had objected to that and basically argued there wasn't grounds in the statute to do that. Plus, it's like a real pain because they're trying to schedule witnesses and have an idea of what's going to happen. And they don't know if Mr. Kohberger is considered to have waived his speedy trial or not. So it just gets very complicated. But so Judge basically like backpedaled on his earlier ruling since, as we are about to talk about, they all indicated they're preparing to go to trial on October the 2nd here. That's where we're at this point. And so it's kind of a moot issue. It doesn't matter because speedy trial doesn't run until after that anyway. So I think to just sort of avoid there being an issue, he just went ahead and took the 37 days off the table.
Yeah, because I mean, the damage is already done. I mean, if we are really going to be seeing the trial in October, what's done is done. It's a wrap. It's a wrap. It's a wrap.
Yes. Yeah. Yeah.
If they were to extend, that would be. I mean, I was expecting the opposite, Andrea. I'm going to be honest. I was expecting you to say, "Oh yeah, they're going to be extending this until October. I mean, until November, December. Shoot, even maybe seeing it well into 2024 because of all this stuff that's going on, all this back and forth. Like I said, it's like a tennis match going on. So the fact that that motion to stay is kind of obsolete in a way. So obviously, for them to go into October is still. For them to be going into October is still surprising, and we'll talk about that in a second. So I'm surprised that they will not. We're not looking at a delay in this trial, for sure. Now, when it comes to the other thing, that this is something that was interesting. The motion to dismiss indictment on grounds of error in grand jury. Can you explain that a little bit for us? Because we're just regular people. We're not superhuman like yourself. So can you explain that to us really quick? What that all means?
Yeah, well, so this is the motion that was not heard today. This one did get kicked down the road, and they rescheduled it. I don't have it right in front of me, but it's going to be within like a couple weeks or so. So they have not heard that one yet. But this is basically just another argument that the grand jury process itself was defective. And so because of that, the indictment should be thrown out. And then if there is no indictment, then, either Bryan Kohberger needs to be released and the grand jury reconvened, or they need to go ahead and do the preliminary hearing to get the finding of probable cause. So that's really what the defense is trying to accomplish with that motion. They're arguing that due to technical defects in the grand jury proceeding, potential bias in the grand jury proceeding, that type of thing, that the indictment is invalid.
Okay. But that was reset, correct?
Yes.
So we are going to be seeing, or they're going to be circling back to that conversation here soon. So it's not fully, they haven't fully made a decision on this or not?
They're coming back to that one on September the 1st at 1 p.m.
Yes. So that's the other question I was going to ask. So why is there a motion to dismiss on the 1st of September?
Yeah, that's this one. That's this one that got reset.
Okay, so it just got reset.
They just did that. Yeah, they just did that this afternoon.
Gotcha. So no answers on that yet, guys. No answers on that yet. Okay, that is fine. And that's the reason why, because somebody just asked that just a second ago.
And I mentioned to you before the show, people may have seen there was some reporting that went out from some sources that said he had dismissed the indictment and had referred to him as Judge Petty. He actually came back on the bench after a short recess in the afternoon to kind of, I don't want to say chastise the media, but he kind of chastised the media that they might want to be careful about their details,
Right.
Make sure they understand what they're reading before they report it. Because what had apparently happened is somebody had gotten a hold of one of the responses that was filed, and attached to the response, the state's response, were a number of rulings from other jurisdictions. And so the final ruling was a ruling from a Judge Petty in Canyon County, who had denied a similar motion. So somebody apparently got a hold of that, thought that was the ruling in this case. It's not. It was just part of the state's document. So if folks did see that being reported, that he denied that motion, that is misinformation that you got from media who reported facts that they didn't understand.
Oops. Yeah, that's crappy. This is the reason why.
By the way, I did want to ask too, because I, of course, didn't see any of the coverage that has come out so far. But I was sitting behind the cameras on that side of the courtroom, and noticed throughout the course of the afternoon, one of the cameras doing exactly, what Judge has told them not to do, panning over to Bryan and zooming in on him and just focusing on him, while people are testifying to get his reactions and stuff like that. It was bad enough to the point that I went and alerted defense counsel to it myself. They may already have been aware, but I just wanted to be sure that they were aware that was happening against the court's order. So I don't know if any of that made it onto the actual, like, what's been released so far.
Yeah.
I'll be interested to find out about that.
Well, I will say this. I mean, they just from there's other places. Law and Crime was very much towards the the witnesses, and of course, or the expert witnesses that they had coming on and all that. The only time that they really spent any time on good old Coco was when he walked in and sat down. I mean, that was really it. And then there was just one big wide shot of the courtroom. For the most part, so they stayed pretty respectful on Law and Crime. You know what I mean? Or they stayed respectful, not pretty respectful. They stayed professional with it and all that for sure. So that dismiss indictment is obviously is going to be circled back on the 1st of September, and then there will be a final kind of decision on that. Yes. But as far as like the motion to compel, their third motion to compel, we're just talking about the defense. What was going on with that? Because I mean, obviously these were kind of talked about briefly. The main one was DNA and the motion to stay. So
the motion to compel basically all got wrapped in with the IGG stuff. Since that was like the main piece of it, there were the other little parts that kind of got brought up casually. Like for example, the unidentified male profiles and the information, pertaining to those samples, their handling and so forth. I think specifically they wanted to know if those samples had been entered into CODIS, and the state, as I recall, was a little annoyed because according to them, they had already told Ms. Taylor that those samples were not eligible to be put into CODIS, which is not saying that they weren't, right?
Right.
So, I'm a lawyer here. Like, I hear what I hear. I never actually said the words, they were not put into CODIS. But that was what we were to understand. That was clarified on the record. So I don't know if that's going to go any further. But yeah, those issues were kind of just dealt with in passing as part of the overall genetic discussion that really focused on IgG.
Right. Yeah, they were very, very big on the genealogy for sure. Yeah. So, of course, we got to talk about the scheduling order. And this is the reason why I say, really, they're going to have this trial by October. And did they settle a date? I don't remember anymore. In October, did they settle a date in October? It is October 2nd. Okay.
October 2nd was the date for the trial.
Okay, I wanted to make sure I was not insane. There's so many dates that keep flying in and out, so many hearings. So the numbers just come in and out of my head. But so October 2nd. I'm going to
throw some more at you.
Oh, I can't wait. Because
it is, of course, still possible that they may not happen, but we're going to have some limits on that now. So first off, at the very end, Ann Taylor requested a status conference for next Wednesday. So that has been set for next Wednesday at 2:15 in the afternoon. Not clear what that was about. She did not specify like what are we having a status about? Is this a status about discovery? Is this a status about what? So to me, I don't know, but my suspicion is this is going to be kind of the fulcrum, point for deciding, are we going forward in October or not? This is having a deadline where the decision has to be made. Are we going to continue it or are we not going to continue it? I don't know. Again, that's just my speculation, but that's what makes sense to me in this context. But even if that doesn't happen, as part of the scheduling order, Judge did set a deadline for a speedy trial waiver in this case. And so if Bryan is going to waive speedy trial and ask for it to be continued, he set a deadline of, let me find it in my notes here, September the 8th. So we will know by no later than, probably a day or so after that. He either waives or he doesn't. If he doesn't waive, then we are going on the 2nd, and that will be that.
Interesting. But there are a lot of things that they still got to go through until October the 2nd. Now, one thing I do want to know, and I know this is like not any part of the hearing that went down, but I am very curious. They're still going to allow cameras in the room during the trial on October?
As long as they behave. as far as we can tell.
Okay.
I mean, I don't
All right.
know. It was there was definitely some issues today. I don't know exactly what happened because I couldn't see everything. I couldn't hear everything. There was some sort of kerfluffle between the bailiff and one of the cameramen. Don't know, kind of possibly looked like some footage was being confiscated or being asked to like go do something. Like, I don't know.
What?
There was definitely some interaction going on between the court staff and the camera people. So the court, I think, is aware that these boundaries keep being pushed. And so, my hope is that they don't lose their access over just trying to get stupid shots of Bryan Kohberger.
So it was just over stupid shots of Bryan Kohberger, and
Just
that's
wanting
all.
to sit there and be zoomed on his face while he's watching the experts testify. This exact thing that judge told them not to do.
Wow. Okay, that's no bueno. That's definitely not no bueno. So real quick, another person just asked this. Didn't they say that they're still missing autopsy reports? I didn't hear anything of that sort, but you were in the room.
Yeah, no, there's been no indication of missing autopsy reports. I do believe those have been provided.
Now, another thing, some people have been saying this in the chat, so I'm gonna ask it.
Mm-hmm.
Because some people are going, ooh, the state be shady. The state's being shady.
Mm-hmm.
What are your thoughts?
I understand the perspective. I mean, the argument is, what is the problem with handing over this IGG stuff? If you didn't do anything wrong, then why don't you want to show us? It's the fact that you're fighting so hard to keep it secret is, what raises a suspicion more than anything else. And then when that's, combined with testimony from somebody who does this work for law enforcement, telling you how she breaks the rules to get them, information they're not supposed to get access to. Well, yeah, that does kind of make you wonder if maybe that's what's going on in the background. Now, does that create a legal issue that's going to create a problem in Bryan Kohberger's case? That's arguable. That was something that they discussed a little bit on the bench today. Okay, if the state went and, or the FBI went and violated the rights of all of these people who, submitted their DNA and opted out of the law enforcement matching, well, that's not really Bryan Kohberger's concern. That's not his right that he gets to assert. So that's a standing issue in the constitutional language. So it's not really clear that would undermine anything from that standpoint. Like, it wouldn't necessarily lead to suppression. But the defense made a very good argument that, well, we might want to cross-examine people on some of this stuff because, that goes to honesty. It goes to credibility. If you're willing to cut corners and break the rules in this part of your investigation, why wouldn't you do it in all these other ones?
No doubt. No doubt. And that's the frustrating part of it all, too, because if they got it in an illegal way, if they got the DNA and they proceeded to do things in a not so kosher way, a lot of this stuff could be thrown out, which is very, very frustrating, especially if you got the guy, especially if you actually have the guy. Okay. I know there's a lot of people out here with a lot of pushback. Basically, there's some Kohberger, pro Kohberger people out here, right, that are saying that they got the wrong guy.
Pro reasonable doubt people.
Fair enough. Pro reasonable doubt people. Okay. Fair on that. Okay. And so, but there's a lot of other people that think, oh, they got their guy. Now, on the side of if they got their guy and they find out, the state finally releases the stuff that the defense is asking for, only to find out that they did it in a not so kosher, or, they did it. They cut some corners, they kind of did some things that they weren't supposed to be doing, lawfully speaking. Then all that stuff could be thrown out the window. And then guess what? He gets to walk. So for the probable cause people, they're going, yay, Hercules. But all the people out here that are saying, hey, we're pro, he did this damn thing. Mm-hmm. It's going to be it's a very polarizing result here at the end of the day.
It is. And that's 100% the reason why they have this rule in the first place. It's the easiest thing in the world for police to follow the rules. We all have to do it. They should do it too. And so if they can't even do that, these are the consequences that you face, and they're still willing to cut these corners. This is why we have defense attorneys. This is why we have consistent, business and opportunities to make hay in cases, because just for whatever reason, law enforcement can't follow the rules. It's an ongoing issue.
You said it, not me. And I say that stuff. Oh, it feels so good to have somebody else say it and not me. Oh my God. I didn't pay her to say that, guys.
No,
just so you know.
Put me out of work, police. I dare you. I would love it. Put me out of work. Follow the damn rules.
But it is true, guys. All right. 5-0 can do some things that they shouldn't be doing, okay, out here. Let's keep it real, just so that they can stick it to the guy or to the person. And in this particular situation, trust me, I'm still on the side of, I feel like they have their guy. Mm-hmm. But there's a lot of things. The fact that the state is being very, very, they're dragging their feet on this whole situation. Yeah. It is frustrating that they're not going, oh, you want our stuff? Here you go. Mm-hmm. There's the evidence. Go ahead and take a look. Go ahead, take your time. You got it all day. We got copies at home. They're not doing that. And it's frustrating because this could be a situation where they really do have their guy, but because of a technicality, for lack of a better term, this could be screw up the whole thing up. Yep, as she said, shenanigans.
You mess up the case for shenanigans.
Yeah, say that again one more time.
You mess up the case for shenanigans.
Bang. Just so you can go, hey, look, this is our guy, and let's break the rules really quick so we can get our guy. Yeah. You can't play dirty in the game, especially when it's something this big. But I will say this too, and I want to put this up here too. Hold on. Where is it? Rachel K just said this. Okay. I wait to see evidence in court. Okay, yes. That's true, because there's a lot of evidence that we have not yet seen, y'all. We 100%. Haven't seen. Yeah, I mean, I would say 95%, or am I being generous?
I think you're being generous.
Yeah, I'm being generous. Okay.
I think you're being very generous. That's the whole thing, though. We just don't know, and we don't know what we don't know. And so until it actually gets to trial and we get answers to some of these questions, that I think is really what defines kind of where you stand on this case right now, is basically just your view of the strength of the probable cause affidavit. For some people, okay, that's enough for them to be convinced it was Bryan Kohberger. For some of us, that's not enough to convince me. And so if we go into trial and that's all the state has, I personally am not convinced by that. But it's just very unlikely that we're going to go into trial and that's all the state has. We don't know what all the other pieces are.
Yes. We don't know everything yet. And I feel like we're going to find out more when the trial actually happens, but I am scared. I am worried because eventually the state has to cough up the stuff, how they got the DNA, everything, their proceedings in which they got the DNA and all that. You got to remember, guys, and the only reason why I'm saying this, because I'm still on the side of, I think they got him guilty, guys, him guilty. But I'm waiting for the trial, and I will be the first to be like, sorry, guys, I was wrong. Oops. Okay. But they I would say, oh, the defense did their thing. They did that. But you got to remember how they got him. Multiple men walked in there. Multiple men wearing badges walked in there. Majority of them, I would assume, were wearing body cameras. They're saying none of them were turned on. They don't have that footage suddenly. That footage just disappeared, guys. So there's a lot. There's
50 law enforcement officers or so, and not a single one has a body cam on.
That's weird, right, guys? Yes. That's a little weird. Okay.
Yes.
That's weird. Now, does that exonerate Bryan Kohberger? No, I'm not sitting here saying that. You know where I stand. Okay. That doesn't say that he did it, but that doesn't say that he did either.
Yeah.
So that's the piece that's very tough. And then what's frustrating is this could blow everything out the water. And we're back at ground zero all over again, where we're looking at Idaho police or Moscow police and basically saying, okay, who you got next? Or do you have any more hard evidence pinned to this man? And I'm not talking some security cam footage of a parking lot that you saw on one random day that people are replaying 15,000 times over in black and white. Come on, guys. Come on.
Yeah.
Evidence. Okay. No disrespect to you guys out there that are playing those videos. No disrespect, but where's the evidence?
Yeah.
Show us the evidence. So if the state does have to show that, so okay, then can we talk about this? Why are they taking so doggone long? I mean, it is taking forever. The defense and Taylor's team has been basically begging, demanding for this evidence from the state. Why is it taking so doggone long? And can they hold on to that till the actual trial in October 2nd?
Yeah. Okay. So 3 things. 1, to answer the last part, no. The judge set a discovery deadline as one of his scheduling order items, and that is September the 1st. By September the 1st, that is the cutoff. If you have not produced it, you're not going to be able to admit that at trial. So
wow.
That's out there. But as far as why it's taking so long, there's a couple reasons. I mean, obviously with this IGG stuff, it's taking a long time because the state doesn't want to produce it at all, right? So they're kicking and screaming and fighting to not have to at all. And it just takes time to litigate that. But with a lot of this other stuff too, it's jurisdictional territory marking is a lot of it. And that's so common when you're dealing with multiple jurisdictions, multiple law enforcement agencies, because, you know, I'm not in law enforcement. I'm not going to profess to understand, exactly how the kind of team mentality works with all of that. But it just does seem to be very strong that everybody is a little bit siloed. They do their own thing. And nobody likes to be told what to do by the other people. So the sense we got today from the discussions and the arguments was that it's really the FBI that is the primary roadblock in this case. The FBI doesn't want to turn stuff over. And the state, in fact, Judge asked the prosecutor very directly, are you telling me that if I made an order of the court, the FBI would not follow it? And the prosecutor basically said, well, I'm not going to say that, and I'm not authorized to speak for the FBI. However, it is the law that they are a separate sovereign. They're not obligated to answer an order from the court. And so what typically happens in cases where state agencies are seeking information that's in the possession of the FBI, they issue this thing called a TUIL letter. And it's just named after a case, and basically requests them to turn it over. The FBI then hands that to their own legal and goes through the review or whatever. And then ultimately the FBI decides we may or we may not give it to you. So that's a lot of what's going on, is that this stuff is in the possession of the FBI. The state's saying it's not ours. We don't have it. We can't get it for you. Yes, maybe, Judge, you can order them to give it to you, but they don't have to comply with that. So that's a big piece in all of this as well. Why is the FBI being so sketch in all of this?
Yeah. And that's odd too. What's up with that, guys? What's up with that? And that all will be either presented or not presented by the 1st of September, correct?
Yes. Yeah.
So they have a couple more weeks. What is it? Less than a couple weeks. I'm sorry. Yeah. They got some work to do.
Yes.
They got what?
They have a lot of work to do. It was a repeated theme throughout the day that there are 6 weeks until this trial date, and there is a lot to do in that time. So if this really is going to go forward, it has to be very, very. It's going to be a tightly managed ship.
This is the reason why I'm saying, are you really sure? You really, really sure we're going to be seeing this trial on October 2nd? For real? For real?
Yeah.
Oh my God.
Like I said, it could by November or by September the 8th, we will know for sure one way or the other. He will either waive or he will not.
So we will know at least within 3 weeks.
Yes.
3 weeks we will know if this is all going down. And then of course, we'll see if the state or if 5-0 at that time did some shady dealings, or if they're just holding all this information until they actually present it on the 1st. But I feel like they would have been shared this a long time ago.
So we have motions for pretrial motions. There's going to be deadlines for that as well. They're going to have to file all those by September the 8th as well. So any motions to suppress, any motions in limine, things dealing with evidence needing to be excluded or whatever. All of that is going to need to be filed by September the 8th. So yes, things are going to get ramping up and happening very, very quickly.
Wow. It's going to be insane, guys. Oh, one other thing though, real quick. Any talk about any other key witnesses, anything of that sort? You know, when it comes to any of the girls that were in the, you know, some of the surviving roommates, so on and so forth. Was there any talk about any of that stuff at all?
None of that has come
hearing?
up. This
Okay.
I think relates again to both parties are being very deliberately vague about all the fact details of the case at this point.
Yeah. Okay. Fair enough. Fair enough. Man, it is crazy. This is a crazy trial. I've never heard so much movement as far as so many motions and so many hearings leading up to an actual trial. This is the first time I've ever seen anything like this in my life personally. But then again, you know, I haven't been watching trials like this with a magnifying glass in such a fashion ever in my life. Is this normal?
This is extremely accelerated, especially for a death penalty case. But honestly, even if the death penalty weren't on the table for this, this was just a, you know, quote unquote, ordinary quadruple homicide. This would still be very, very fast from my perspective. You know, six months from indictment or whatever is just not, it's not a long period of time. I normally expect these types of things to take, you know, a year or longer to get prepared. So no, this is a very accelerated schedule.
Yeah, this is, I'll be honest, this was fast. But I've never seen so many motions before. But then again, I'm not a lawyer, you are. I mean, is this a normal procedure?
Yeah.
With this amount of motions that have happened in this trial. And I get it's a death penalty trial. That's some serious stuff. She, you know, her job is to save his life. But is it normal, the amount of motions and hearings that they've had leading up to October 2nd?
Yeah, from my perspective, the volume is pretty normal. We're seeing about what I would expect to see. You would like there to not be discovery motions, you know, you'd like there not to be the need for that type of thing, but that's just kind of the reality of the process. So it's not really surprising that does happen. So yeah, everything here volume wise looks pretty normal to me. They're just compressing it into such a short period of time that I don't know when anybody is getting any sleep.
Yeah, no kidding. I was going to say, she, Ann Taylor is on some serious, she on coffee, like just Red Bull and coffee. That's it.
Oh, Judge commented about how he'll be working at night, you know, for the next 6 weeks. So if that's what they want to do, they're going to make it happen.
Wow, that's crazy, guys. So there is a good possibility, everyone. There's a strong possibility that we will see it before the end of the year. Yeah. That we will see it before Halloween.
Less than a year from the crime itself, which to me is absolutely astounding.
Yeah, that's very, very surprising. How long do you think this trial is going to last for? Like the runtime of it?
Yeah, so they have scheduled it to run for 4 weeks for the guilt phase, and then if necessary, another 2 for sentencing.
Oh, wow. So if it goes in October, it's going straight through Halloween. Straight through Halloween and everything, guys. So that's, wow. That is insane, guys. This is going to be, I will be, see, that's the other thing. They won't be live streaming it, I don't think.
I doubt it. I mean, they might do it on this delayed replay like they've been doing, but I doubt that they will live stream it, especially, I mean, frankly, just, with the behavior of the camera people. They just don't seem willing to abide by the restrictions. And so I think that just makes it less likely.
That's frustrating because I want to be like, cameramen, act your age, okay? Just be mature. I don't understand why everybody's being weird like this. Like, you're going to be seeing him plenty in the next couple weeks. Just let it go, baby. Let it go. Because I would love it to be live. I would love it to be streaming live because I would be watching that with popcorn. Trust me, this will be the watch party of the century in my personal opinion, especially if they're using DNA. And of course, I'm really interested in the 99.5% of the evidence that we haven't seen yet.
Yes.
I'm really looking forward to seeing what they have and what the defense has against prosecution. It's going to be, like I said, it's going to be the trial of the decade, century. I don't know. I'm being generous again, but still.
Well, I agree. I mean, I think this is going to be an absolutely fascinating trial to watch, in part because it is, from what we know so far, kind of so thin. You know, this is not, I think what we're used to when you look at cases like, I mean, for example, you just compare the probable cause affidavits from the Long Island serial killer with the Bryan Kohberger, and just the volume of what they have, the circumstance upon circumstance upon circumstance. It's, yes, still a circumstantial case, but my God, look how much stuff they have, stacked up to really point at him.
Right.
And they just don't have that much with Bryan Kohberger. So those links and those connections become all that more important. Those details matter so much. And so that's what makes it a fascinating trial, is to see if those details are going to stand up.
I can't wait for it. Andrea, I cannot wait for it. We're going to be here watching it for sure. Of course, Andrea has been amazing and giving us her time, especially just getting out of that courtroom just minutes afterwards, being on live with me to give you guys some more understanding of what happened inside those four walls. It is pretty crazy. So I want to say a big thank you to Andrea. Please go and check out her YouTube channel. And also, she's been blowing up lately. I see you've been blowing up because of the Heard Netflix series, right?
Yeah, apparently I'm in the Netflix documentary. I don't know. They ripped off some of my content and used it, and I'm getting a whole bunch of new followers. So that's great. Welcome, everybody. Come one, come all.
Come on in. The water's just fine.
Thank you to Netflix for showing you where to find good, high-quality legal analysis and all of the court documents you would ever want to see.
Wow. And what's crazy is, I'm just really quick, just touching on that Amber, the Depp v. Heard situation. I'm hearing some content creators are actually trying to seek legal action towards that because of the footage that was used in the series.
Yeah, so a lot of people, and especially I think the big one is Popcorn Planet, and also that Umbrella Guy. I believe both of them were contacted for permission to license their clips. They did not grant that permission, and then those clips were used anyway. At least in the case of Popcorn Planet, it was pretty substantial, like quite a bit of stuff. The question is always, is it fair use? And fair use is this kind of nebulous standard. As content creators, certainly we like it, we appreciate it, we understand it. Yes, people do have fair use rights to use our own footage, but that doesn't mean you get to just rip it off and recreate it, without transforming it in some kind of important way. So,
yes,
those are very important questions. From my personal perspective, I haven't watched the Netflix documentary. I'm really not interested in watching the Netflix documentary. I mean, I know a hell of a lot more than Netflix does about that case anyway. So, what good is it going to do me?
You ain't wrong.
Yeah. So I'm not really concerned about it for my own case, but I definitely support those people that are interested in looking at further recourse. Mainly just because what is good for the goose should be good for the gander. For Netflix to use Andy Signore's footage and then copyright strike him for critiquing their documentary using his footage, no, that's not acceptable. That should not stand.
It's kind of jacked up. It's kind of jacked up. Let's keep it real. And I haven't seen it yet either. Well, the only reason why is because I lived through it too. You know what I'm saying? I watched the whole thing, not the whole thing, but a good majority of it. And I feel like, what's the point of reliving something that I've already lived through already? So that's just me. I watched maybe 5 minutes of it and I was like, oh, there's Andy. Oh, there's Tug, there's Ricada Law, or there's Emily D. Baker, or what I'm saying? I was like, oh, all these people I know, this, that I watch. Cool. It's good to see them on here. But I was like, I've already seen all this. So why relive all this all over again? But that's just me, but I was wondering what you thought about that, if that was grinding your gears or if that was something you were cool with.
Yeah. No, I mean, I did not license them to use it. But, am I going to kick and scream? Probably not. I don't know. Yeah. I don't really care that much. It kind of comes with the territory, when you create content, people are going to use it. People are going to want to talk about it. They're allowed to do that, and they're allowed to do that in ways that are critical. So, It is what it is.
It is what it is, for sure. But really quick, guys, again, Andrea, thank you so much for being here and giving us your knowledge, breaking it down for us layman's out here. Do not forget to go check out her YouTube channel, okay? It is at A. Burkhart Law, okay? And that's also her Twitter or her X account as well. Please go follow her at A. Burkhart Law on Twitter. Her Twitter's just blowing up, y'all. Just blown all the way up. And it's rightfully so. You deserve it because you're very, very, very good at what you do. So I appreciate you coming on as always. And we'll be talking to you very soon. Hopefully are you going to be going to this September 1st?
I gotta get home and check my calendar. But, in fact, the August 23rd, next week, I gotta look at next week. I don't know yet where I'm at. So my goal is, yes, to be here for as much as I can. So far, the only specific scheduling conflict I know that I have is that if the trial does go forward on October the 2nd, there's going to be a period somewhere in the middle where I won't be able to be there because I have to go argue a case in the Washington Supreme Court. So I won't be able to be here. But other than that, my goal is always to be here for everything.
Right on. Okay. Well, of course, I'll be annoying you and everything to see if you can come on and break down what you saw, just being a fly on the wall and all that. So I appreciate you coming on and have a safe drive back home and enjoy a cold one on me. All right.
Thank you so much. Will do. Have a great one, Pascal.
You too. Bye.
Bye-bye.
All right, guys. Well, that is the show. I appreciate all y'all for being here. But yes, a few takeaways. There's going to be a few more things that they need to take care of before everything pops off, before they finally make that decision on if the DNA is going to be played, a card being played in this trial or not. We will know for sure on the 1st of September, or at least they have to cough up proof. They got to cough up how they got the DNA and all that stuff. The state has to do that by the 1st of September. So at least by the top of September, we should know some thizangs. Real talk. If they're going to play that card or not. Of course, there's a bunch of other little things that they got going on, but as soon as those things come out, for a fact, I'll be bringing those things up and giving you guys those updates as well. And hopefully, Andrea, as she has been doing as of late, hopefully she'll be able to come onto the show and break it down for us, and explain everything to us as best as she has been doing this entire time. But anyway, guys, I appreciate all y'all for being here. I appreciate y'all. It's very interesting. Things are moving with this case, with this trial. It's going to be interesting. If it actually happens on October 2nd, I'm really interested to see what's going to happen, how they're going to proceed, what defense is going to do, what the prosecution is going to do, how they're going to present their arguments. And then on top of that, also, for us, because I'm selfish, I want to see it. So I'm interested. I hope that they actually show the whole thing live, because that's what I'm interested in. I don't want to watch the whole thing later. That could be fine too, but I don't know. The scheduling of watching something like that, would be tough. You feel me? So I hope that they actually do this live so that we can watch it live together as a family. If not, we'll figure it out. But don't you worry. Don't you worry about a thing. We're going to be watching it. It just may be in a weird way, okay? If that makes any sense. We're going to figure it out. We're going to figure it out. Trust. This is a huge case, and I know everybody wants to see every single moment, because every single moment is crucial. He is fighting for his life right now. So we'll see how they present it. Anyway, guys, I appreciate all y'all for being here. Please do not forget to hit that like button on your way out. Hit that reaction button if you're on Facebook on your way out. That'll be greatly appreciated. And if you're on Facebook and you like this conversation and you feel like somebody else would appreciate the breakdown of today's hearing, please share this on Facebook off of the Pascal Show Facebook page, okay? To my Facebook fam, thank you, okay? And of course, do not forget to hit that subscribe button as well. Crush it, y'all. If you're watching on YouTube, if you're watching on Facebook, hit that follow button up top. Hit that follow button, okay? I've been covering this story for a very long time and will continue to do so. But of course, there's a lot of other stories that I'm bringing to light, shedding light on other very important pieces, very important cases and stories. So please be sure to hit that follow button over there. Hit that subscribe button if you're watching on YouTube. Hit that join button as well on YouTube. Become a member. All right. Support this channel. That would be amazing. I'd really, really appreciate it. Anyway, guys, it is time to get going. Enjoy your weekend. I may be doing a pop-up video depending on what time, because there is some updates on another case that I want to bring some updates to you guys that are crucial. So I may be doing a pop-up here in a little bit, but I might not. I might hold it for tomorrow. Regardless, if I don't see you guys, have a great, positive, and fulfilling weekend. I think y'all deserved it. So go do something that makes you smile, okay? Do something positive for yourself. Anyway, guys, it's time to get going. I appreciate all y'all, and I'll see you guys very soon. Be good to yourselves. Be good to one another. Have a great weekend. This is The Pascal Show. Bye.